Hi. So we are going to discuss about the nature, the law, the purpose of preliminary investigation in the Philippines. So what is preliminary investigation? As it being defined in Rule 112 on the Rules of Criminal Procedure, it is said that preliminary investigation is an inquiry or proceeding to determine whether there is a sufficient ground to engender a well-founded belief that a crime has been committed and the respondent is probably guilty thereof and should be held for trial. So in other words, preliminary investigation is the proceeding where the prosecutor or the public prosecutor is given broad discretion to determine whether probable cause exists for the purpose of filing a criminal information in the court. So this is called to be the executive determination of the probable cause. So in other words, preliminary investigation is an investigation conducted by the public prosecutor for him to know if there is a probable cause to believe that a person is probably guilty thereof and he need to be held for trial. So preliminary investigation is required to be conducted before the filing of a complaint or information for an offense where the penalty prescribed by law is at least 4 years, 2 months, and 1 day without regard to the fine. So, lahat ng kaso na kung saan yung penalty niya, impossible penalty is not less than 4 years, 2 months, and 1 day, regardless of the fine, then preliminary investigation should be conducted before the case will be filed to the court or before a complaint or an information will be filed to the court. So what is the nature and the effect of preliminary investigation? So first is it is a merely inquisitorial. When you say inquisitorial, it will determine whether or not, or it inquire whether or not the person is probably guilty, or they will look for the probable cause of a certain crime for him to be complained or for so that there will be a complaint filed or an information to be filed against him or her. It is only means of discovering whether the offense has been committed and the person responsible for it. Third, to enable the fiscal to prepare his complaint and information. Fourth, not a trial on the merits. Fifth, determine whether there is a probable cause to believe that an offense has been committed and the accused is probably guilty thereof. And 6, doesn't place the accused in jeopardy. 7, doesn't affect the jurisdiction of the court, or only the regularity of the proceeding. It is just a regularity of the proceeding. 8, accused cannot assert lack of preliminary investigation. Court cannot dismiss the case based on this ground. It should conduct the investigation or order the fiscal or the lower court to do it. 9, preliminary investigation may be waived. 10, accused should invoke right to preliminary investigation before plea. Otherwise, it is deemed waived. 11, accused doesn't have full gamut of rights yet, and it doesn't have right to counsel unless a confession is being obtained from him. And 12, there is also no right to confront witnesses against him during preliminary investigation. So that's preliminary investigation. So when is preliminary investigation is required? So as been stated earlier, it will be only required to those cases wherein the imposable penalty prescribed by law is at least 4 years, 2 months, and 1 day without regard to the fine. So a preliminary investigation is not required in cases of warrantless arrest. So in cases of warrantless arrest, no need to have preliminary investigation. Instead, they will follow inquest proceeding. So yun. So when a person is lawfully arrested without a warrant involving an offense which requires a preliminary investigation, the complaint or information may be filed by a prosecutor without need of such investigation, provided an inquest has been conducted in accordance with the existing laws. However, after filing the complaint or information in court without a preliminary investigation, the accused may, within 5 days from the time he learns of its filing, ask for a preliminary investigation. So in other words, kapag yung tao hinuli without warrant or through warrantless arrest, no need to have a preliminary investigation as long as the investigator follows the increased proceeding for warrantless arrest. So if ever the person or the arrested person, the prosecutor already filed a complaint without preliminary investigation, after 5 days knowing that there is a filing of complaint or information, the accused may ask for preliminary investigation if there is no preliminary investigation. So kapag walang preliminary investigation tapos na-file na yung kaso, so yung accused pwedeng mag-request or can ask preliminary investigation. Okay? Sorry. So who are the officers authorized to conduct preliminary investigation? So according to the law, it is the provincial or city prosecutors and their assistant may conduct preliminary investigation. Judges of the Municipal Trial Court and Municipal Circuit Trial Court or MCTC, the national and regional state prosecutors and other offices as may be authorized by law, and their authority to conduct preliminary investigation shall include all crimes cognizable by the proper court in the respective territorial jurisdiction. But in cases wherein the case is related to if the case is related to election offense ba yun? So if that is related to election cases, okay, so if the offense is in relation to election offenses, the COMELEC is vested with the exclusive authority to conduct preliminary investigation related to election laws. So including acts of omission constituting election fraud, offenses, and malpractice. He or she may design a prosecutor, its deputy, who thus placed under his supervision and control. So COMELEC has the exclusive power to conduct preliminary investigation of all election offenses punishable under the election laws and to prosecute the same. So the Commission can appoint or designate deputies to conduct preliminary investigation under the defect supervision and control. So election offenses may be done upon motu proprio by the Commission or upon written complaint by any citizen of the Philippines, by the candidates, by registered political party or coalition of political parties, or organization under the party list system, or any accredited citizen arms of the offenses. And the officer who can conduct PI in election offenses are the following. It could be the COMELEC legal officer, Solicitor General, the Chief State Prosecutor, all provincial prosecutor and their assistant, all city prosecutors and their assistants. So maybe directly filed with them or endorsed to them by the Commission or its duly authorized representative, and to prosecute the same. So in cases wherein violation of in cases wherein it involves the act or omission of any public officials, employee, or office or agency. So it is said that the one who has the general investigatory power of this, or the one who will conduct preliminary investigation, is the Ombudsman. It will only be done by the Ombudsman if it appears to be illegal. So the act of the public official, employee or office is illegal, unjust, improper, or inefficient. So the Ombudsman has the authority to conduct such preliminary investigation of criminal complaints and to file it in the Sandigan Bayan and the corresponding criminal information when the evidence so warrant. So the power of the Ombudsman to extend to any illegal illegal act or omission of any public official, whether or not the same is committed in relation to his office. So, share with the PCGG for cases of ill-gotten wealth and unexplained wealth under Executive Number 1, 2, 14, and 14-A. So, the state and the city prosecutor may conduct preliminary investigation. So, the Ombudsman can act on any complaint filed in any form or manner, which includes unsigned or unverified complaint, testimony given at a fact-finding investigation, and charges made in the pleading in a case in a court. So those are people who are authorized to conduct preliminary investigation. So other than these people listed here below, so the COMELEC and the Ombudsman may conduct preliminary investigation, but of course in relation to their territorial jurisdiction. Okay, how shall preliminary investigation be conducted? So, paano ba gagawin ang preliminary investigation? So, the preliminary investigation shall be conducted in the following manner. First, the complaint shall state the address of the respondent and shall be accompanied by the affidavit of the complainant and his witnesses, as well as other supporting documents to establish probable cause. So, they shall be in such number of copies as there are respondents plus 2 copies for the official file. And the affidavit shall be subscribed and sworn before any prosecutor or government official authorized to administer oath, or in their absence or unavailability before a notary public, each of whom must certify that he personally examined the affiants and that he is satisfied that they voluntarily executed and understood their affidavit. Second, within 10 days after the filing of the complaint, the investigating officer shall either dismiss it if he finds no ground to continue with the investigation, or issue a subpoena to the respondent attaching to it a copy of the complaint and its supporting affidavits and documents. So the respondent shall have the right to examine the evidence submitted by the complainant, which he may not been furnished, and to copy them at his expense. If the evidence is voluminous, the complainant may be required to specify those which he intends to present against the respondent, and this shall be made available for examination or copying by the respondent at his expense. So object as evidence need not be furnished a party, but shall be made available for examination, copying, or photographing at the expense of the requesting party. Third, within 10 days from the receipt of the subpoena with the complaint and the supporting affidavit and document, the respondent shall submit his counter affidavit and that of his witness and other supporting documents relied upon for his defense. So the counter affidavit shall be subscribed and sworn to and certified as provided in paragraph A of this section. And then, of course, there should be copies furnished by him to the complainant. Respondent shall not allowed to file a motion to dismiss in lieu of a counter affidavit. Fourth, if the respondent cannot subpoena, or if subpoena does not submit counter affidavit within 10-day period, the investigating officer shall resolve the complaint based on the evidence presented by the complainant. And fifth, the investigating officer may set a hearing if there is a fact and issue to be clarified from a party or a witness. So the parties can be present at the hearing but without the right to examine or cross-examine. They may, however, submit to the investigating officer questions which may be asked to the party or witness concerned. So the hearing shall be held within 10 days from the submission of counter affidavit and other documents, or from the expiration of the period for their submission. It shall be terminated within 5 days. So sixth is, within 10 days after the investigation, the investigating officer shall determine whether or not there is a sufficient ground to hold the respondent for trial. So that's how preliminary investigation be conducted. So medyo taas. So these are the basic steps and the subsequent paragraph on preliminary investigation. Of course, first is filing of the complaint or the affidavit. Issuance of subpoena by the investigating officer to the respondent. Third, filing of counter affidavit by the respondent. Fourth, if allowed by the prosecutor, filing a reply affidavit by the complainant and rejoinder affidavit by the respondent. And the last but not the least is resolution. So these are the 5 basic steps. So kung imo tong basahon balik tong procedure, mo na siya ang pinaka-basic or shortened procedure. Okay. So what are the requirements in filing a complaint or complaint affidavit? So the complainant shall state the address of the respondent and shall be accompanied by the affidavit of the complainant and his witness, as well as other supporting documents to establish the probable cause. They shall be in such number of copies as there are respondent, plus 2 copies for the official file. The affidavit shall be subscribed and sworn to before any prosecutor or government official authorized to administer oath. So in other words, the complaint tsaka the affidavit dapat it was created or it was being done under oath or under oath. So and this oath will be done in the presence of the prosecutor or any government official. So if there is no prosecutor or government official authorized, so it can be done before a notary public. And each of whom must certify that he personally examined the affiant and that he is satisfied that the voluntarily executed and understood their affidavit. So complaint is also generally required to pay filing fees. So what happens if there is no probable cause? So if there is no probable cause, the investigating prosecutor shall recommend the dismissal of the complaint. So kapag walang probable cause, if the prosecutor found out that there is no probable cause, automatically he will recommend the dismissal of the complaint. So inana lang siya. Because for him, what's pa may pulos? What's the point of holding a trial if there is no probable cause? So yun, sayang-sayang ra. So what happens if there is a probable cause? So if the investigating prosecutor find cause to hold the respondent to trial, he shall prepare the resolution and information. He shall certify under oath and affirmation that he, or as shown by the record as authorized officer, has personally examined the complainant and his witnesses, that there is a reasonable ground to believe that a crime has been committed and that the accused is probably guilty thereof, that the accused was informed of the complaint and of the evidence submitted against him, and that he was given the opportunity to submit controverting evidence. So which is, they are given 5 days from this resolution. He shall forward the record of the case to the provincial or city prosecutor or chief state prosecutor. And if for ombudsman or his deputy in cases are cognizable by Sandigan Bayan or those cases involving public officials, then they shall act on the resolution within 10 days from the receipt thereof and shall immediately inform the parties of such action. So it is said that no complaint or information may be filed or dismissed by an investigating prosecutor without prior written authority. So before they were going to dismiss a certain complaint or information, no complaint or information may be filed or dismissed by an investigating officer without written authority or approval from the provincial or city prosecutor or chief state prosecutor or the ombudsman or his deputy. So in case of Kisay versus People of the Philippines, Supreme Court pronounced that information filed by the assistant city prosecutor is void if there was no prior written authority from the city prosecutor, even if the information contained a certification that the assistant city prosecutor had prior written authority from the city prosecutor. So where the investigating prosecutor recommends the dismissal of the complaint, but his recommendation is disapproved by the provincial or city prosecutor or the chief state prosecutor or the ombudsman on the ground that the probable cause exists. The latter may, or by himself, file the information against the respondent or direct any other assistant prosecutor or state prosecutor to do so without conducting another preliminary investigation. If upon petition by a proper party, such rules as the Department of Justice may prescribe or upon motu proprio, the Secretary of Justice reverse or modifies the resolution of the provincial or city prosecutor. Okay, so in that case, without written approval from the city prosecutor, so dili pwede i-dismiss ang complaint or ang information. So, is hearsay evidence admissible in preliminary investigation? In the case of Senator Estrada versus Office of the Ombudsman, the Supreme Court answered in the affirmative to wit that probable cause can be established with hearsay evidence as long as there is a sustained substantial basis for crediting the hearsay. So hearsay evidence is admissible in determining probable cause in a preliminary investigation because such investigation is merely preliminary and does not finally adjudicate rights and obligation of parties. So that's the answer of Supreme Court. So sabi ni Supreme Court, ang hearsay daw, ang probable cause daw, pwede daw siya ma-establish even in a hearsay evidence. Anyway, ang hearsay is not it's not final actually. So it can be used or it can establish probable cause during preliminary investigation. Okay? So, cases not required preliminary investigation nor are covered by the rules on summary procedure. So, if filed with the prosecutor, if the complaint is filed directly with the prosecutor involving an offense punishable by imprisonment of less than 4 years, 2 months, and 1 day, the procedure outlined in Section 3 of Rule 112 shall be observed. The prosecutor shall act on the complaint based on the affidavit and other supporting documents submitted by the complainant within 10 days from its filing. So, if filed with municipal trial court, if the complaint or information is filed directly with the municipal trial court or municipal circuit trial court for an offense covered with this section, which is not less than 4 years, 2 months, and 1 day, the procedure in Section 3-A of the Rule 112 shall be observed. If within 10 days after the filing of the complaint or information, the judge finds no probable cause after personally evaluating the evidence or after personally examining in writing and under oath the complainant and his witnesses in form of searching questions and answer, he shall dismiss the same. He may, however, require the submission of additional evidence within 10 days from the notice to determine further the existence of probable cause. So, if the judge still finds no probable cause despite of additional evidence, he shall, within 10 days from its submission or expiration of said period, dismiss the case. When he finds probable cause, he shall issue warrant of arrest or a commitment order if the accused had already been arrested and hold him for trial. However, if the judge is satisfied that there is no necessity for placing the accused under custody, he may issue summons instead of warrant of arrest. So, yun. So, that would be all. I would like to say thank you for listening and hope you learned from it. Thank you. God bless.